Yet another abomination of a decision from the United States Supreme Court. This one coming in late yesterday. Dealing with Linda McMahon, Secretary of Education, and the Trump administration, the reduction in force, the RIF, that McMahon instituted at the Department of Education, as well as Trump's executive order. And it's just so disappointing. This is yet another emergency application. We've talked about it a lot here at the Katie Phang News Channel. We've talked about how it's absurd that the Trump administration has found this new way of using this shadow docket to its advantage to be able to obtain relief that it otherwise is not getting at the trial court and the appellate court levels, because it's just wrong. Like, it's just wrong on the law. And as I've made the comparison, it's like a little boy running to hide behind mommy's skirts. That's exactly what this administration does when it goes to run behind the SCOTUS uber conservative majority of 6. And now they've given, once again, the Trump administration a pass to be able to do horrific things to our American workforce. And because it's coming from the Supreme Court, it gives this imprimatur of credibility, because it's the court of the end, right? There's nothing beyond the United States Supreme Court. So let's dive deep into this decision, of which 19 pages of it is the dissent by Justice Sonia Sotomayor. And it's so worth it to walk it through with you guys because, one, there is zero explanation provided by the majority. So I talked about this with Leah Littman on her fantastic podcast, Strict Scrutiny. Kate Shaw, Melissa Murray, Leah Littman, because it's a summer, I went over and I had the privilege of co-hosting with Leah last week. And if you'll go back, and I urge you to go and listen to our episode, but Leah and I talk about the fact that the laboring or the work is being done by the trial courts. And in this particular instance, and we're going to get into it in a minute, not only was it the trial court, but the appellate courts actually were doing work too. But when you have these emergency applications and then you get these rulings where literally the majority opinion is just this. I hope you can see this. It's just this out of 19 pages. And when you're not provided with a roadmap or an explanation that explains why the majority decided the way it did, then it provides zero benefit to the lower courts, because then you're left to wonder why the court ruled the way it did. I mean, you and I know the answer, right? They ruled the way that they did because they are clearly not immune to the cult of personality, which is Donald Trump. But that's why it's worth it to walk through the dissent, because once again, the dissent being either Ketanji Brown Jackson, Sonia Sotomayor, Elena Kagan, these justices are actually having to explain the law. They're explaining why the majority gets it wrong, but then they're explaining the law because, God forbid, the law actually gets explained to the American people so they understand why thousands of people have now lost their jobs, why thousands of migrants are now being kidnapped and shipped off of United States soil. I could go on with the travesty. So let's walk through this together and buckle up. School is in session. Let's go back to law school. So the majority is this one paragraph, and it basically says that the preliminary injunction that was entered by a federal judge in the District Court of the District of Massachusetts, that injunction is stayed, meaning it is put on the back burner. It is put on chill. It's put on ice. It's not going, and not Immigration Customs Enforcement. It has no enforcement right now, while the pending appeal in the First Circuit of the original judge's decision, right, is being litigated. And again, as we've talked about with Supreme Courts, you have to file a petition for writ of certiorari normally to be able to have the Supreme Court take the case. Unless you're the Trump administration, you do one of these ridiculous number of emergency applications. Should cert be denied, then the stay, meaning the block against this judge's nationwide injunction, will terminate automatically. But if cert is granted, meaning the Supreme Court takes this case after it's gotten its disposition on the First Circuit Court of Appeals, then the block on this judge's order will terminate upon the sending down of a judgment from the Supreme Court. That's all it says. It basically reiterates procedure. Thank you, SCOTUS majority. We got it. We've seen so many of these now that you don't have to go to law school to understand what is happening procedurally here, but that's all they do. So Justice Sotomayor, she kicks it into overdrive, and thank God for the rule of law and justice with Justice Sotomayor. So let's get into this. Justice Sotomayor, with whom Kagan and Jackson join, writes straight out of the gate the following. This case arises out of the president's unilateral efforts to eliminate a cabinet-level agency established by Congress nearly half a century ago, the Department of Education. As Congress mandated, the department plays a vital role in this nation's education system, safeguarding equal access to learning and channeling billions of dollars to schools and students across the country each year. Only Congress has the power to abolish the department. The executive's task, by contrast, is to, quote, take care that the laws be faithfully executed, end quote. Sotomayor making it clear that there is a true separation of powers. Congress can abolish a department that was congressionally created. The president's task is what, as the executive, to take care that the laws are faithfully executed. Separation of powers. Okay. And again, this is worth reading in its entirety to you because there is so much impact from Justice Sotomayor's words. Quote, when the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. Two lower courts rose to the occasion, preliminarily enjoining the mass firings while the litigation remains ongoing. Rather than maintain the status quo, however, this court now intervenes, lifting the injunction and permitting the government to proceed with dismantling the department. That decision is indefensible. It hands the executive the power to repeal statutes by firing all those necessary to carry them out. The majority is either willfully blind to the implications of its ruling or naive. But either way, the threat to our Constitution's separation of powers is grave. Unable to join in this misuse of our emergency docket, I respectfully dissent. Kind of surprised Sotomayor used the adverb respectfully because she's getting to the point where she's just basically saying, I give you the middle finger with no respect. So let's take 1 second to backtrack and just talk about this. So the Trump administration basically fired 1,400 employees in the Department of Education. The Trump administration made it clear that it's going to dismantle the Department of Education. It has done so explicitly. It has said so. Linda McMahon has done it. Donald Trump has done it. There's no secrets there, right? So what happened was there were a group of 19 states that were led by New York, as well as the District of Columbia, 2 public school districts and teachers unions, and they sued in federal court in Massachusetts, saying that those reduction in force, the RIFs, violated both the Constitution and the federal laws governing administrative agencies. So a district court judge enters a nationwide preliminary injunction saying you cannot do this reduction in force. You have to bring back any employees that were terminated as a result of that RIF, and you cannot take things like student loans and other parts of the Department of Education and move them to other federal agencies. Then that was appealed to the First Circuit, and the First Circuit said, you know what? We're not touching that district court judge's preliminary injunction. We're going to leave it in place. And so on June 6th, the Trump administration ran to mommy at the Supreme Court and did an emergency application asking the justices to put that district court judge's preliminary injunction on hold. And this is what ended up happening. And that's what we got. Alrighty. So Sotomayor goes on to say, Congress told the Department of Education and gave the Department of Education as a federal agency the ability to do many things that benefit us as Americans. They administer a broad range of educational programs at the Department of Education. For example, the department runs the federal student financial aid system. The department's Office of Civil Rights enforces several anti-discrimination laws as to federally funded educational programs. The department additionally administers the Individuals with Disabilities Education Act, which funds and supports special education services for more than 7 million students with disabilities. Tens of millions of low-income families rely on financial assistance programs administered by the department under Title I. Put simply, schools and students in every state rely on federal programs established by Congress and run by the department. Established by Congress. Keep that forefront in your mind. Congress, what Congress creates, only Congress can take away. Remember that rule. She goes on in the opinion to say the following in the dissent. About a week into her tenure, Linda McMahon announced a reduction in force that would eliminate nearly 50% of the department's workforce, slashing the number of employees from 4,133 to 2,183. In statements to the press, McMahon confirmed the reduction was, quote, the first step on the road to a total shutdown of the department as directed by the president. On March 20th of this year, Trump formalized his directive to shutter the department by signing Executive Order number 14242. So let's get into the actual procedure. Let's talk about how the sausage is made. So to get to the preliminary injunction stage, evidence has to be presented by the plaintiffs in this case. And the defense, the department, Linda McMahon, they also can and should be presenting evidence. And during the course of the hearing, this judge, the trial court judge, this federal district court judge, takes testimony, reads affidavits, considers all the evidence, determines the credibility of the people that are providing this information, and then comes to his or her ruling. And in this case, this judge did exactly that. The plaintiffs, the school unions, the states, the teachers, etc., they presented all this evidence to the judge. Sotomayor makes it clear. The government submitted no evidence to rebut the factual record that was compiled by the plaintiffs, nor did it argue that the executive could single-handedly abolish the department. Instead, it asserted that the mass termination fell within the president's authority because it was simply part of an effort to, quote, streamline the department. The district court granted the preliminary injunction motion. The court found that the record abundantly reveals that the defendant's true intention is to effectively dismantle the department without an authorizing statute, and that the terminations would prevent the department from carrying out its statutory functions. That unilateral executive action, the district court concluded, likely violated the separation of powers and the take care clause. Period. Stop. Let's talk. So, if you have something called a record, which is the official kind of body of evidence that can be considered by the trial court and by an appellate court. And if the trial court judge is the person who is best situated to determine the true intentions of the parties, to evaluate the credibility of the parties, to weigh the evidence that has been admissible and has been entered into this case, then why not show the deference to the trial court that it is due? In fact, the law requires that you show deference to the trial court. And in this instance, the Supreme Court said, whatever trial court, and in this instance, whatever appeals court, we know better than you, although not giving an explanation as to why they know better. Let's move quickly on. The district court stopped the government from being able to carry out its directives, the executive order and the transfer order, meaning the transfer of those student loans to another agency and the reduction in force, etc. It ordered the Department of Education to reinstate those federal employees, to restore the department to the status quo. The First Circuit Court of Appeals denied the government's request to stop that preliminary injunction from moving forward. The government, according to the First Circuit, concluded that it did not even attempt. The government did not even attempt to engage the district court's record-based findings about the extent of the reduction in force, the intent behind both it and the transfer of functions, or the disabling impact of those actions. The First Circuit noted that the plaintiffs faced serious irreparable harms from the department's inability to provide its statutory mandated services. And this is where Sotomayor turns on the burn. Rebuffed twice below, the government now tries its hand at seeking emergent relief from this court. Granting such relief is a matter of this court's discretion, which we have previously exercised only under extraordinary circumstances, end quote. So Sotomayor is reminding her colleagues on the bench, emergency relief by way of the shadow docket emergency applications, it's supposed to be given sparingly, and it's only supposed to be done in, quote, extraordinary circumstances. It's certainly not supposed to be done when a trial court and an appellate court has said that that preliminary injunction is not only kosher, but is necessary to prevent irreparable harm. An applicant for emergency relief bears an especially heavy burden to justify our intervention, whereas here, the matter remains pending before the Court of Appeals and 2 lower courts have already denied that interim relief. All true. Sotomayor reminds the majority that the law stands as follows. The president lacks unilateral authority to close a cabinet-level agency. Congress created the department and only Congress can abolish it. Rather than contest these bedrock legal principles, the government below contends that the mass terminations were not part of any planned closure, but are just to cut bureaucratic bloat. The record unambiguously refutes the government's account. The record evidence, credited by the district court and unrebutted by the government, leads to one conclusion. The executive has seized for itself the power to repeal federal law by way of mass terminations in direct contravention of the Take Care Clause and our Constitution's separation of powers. And we're just going to kind of fast forward. I urge you to read the entirety of this opinion because it's well worth reading. And let's just get to the very end, the last paragraph of Sotomayor's dissent, where she says, the president must take care that the laws are faithfully executed, not set out to dismantle them. That basic rule undergirds our Constitution's separation of powers. Yet today, the majority rewards clear defiance of that core principle with emergency relief. Because I cannot condone such abuse of our equitable authority, I respectfully dissent. Again, I will link this opinion because it's worth it for you all to take the time to read it. And it's amazing because Sotomayor writes in a way that we can all understand. We don't have to be lawyers to understand. I want to just take a minute to kind of just conclude with the following. It's the Department of Education, people. It is such an important federal agency. It was such an insult and slap to the face of Americans when Trump put Linda freaking McMahon in charge of that department to begin with. I mean, what an absolute diss to the value of education. But then when Trump made it clear that he wanted to dismantle the Department of Education, I mean, look, I get it. He's about as ill-educated as they come. But that doesn't mean that the rest of us have to live in ignorance and have to suffer because Trump doesn't value education. Trump values loyalty. That's the only reason why McMahon got her job. But what an uphill battle that Sotomayor, Ketanji Brown Jackson, and Elena Kagan have to fight. To have to push back and to remind their colleagues that the separation of powers is something that is supposed to be undisturbed. It is distinctly within our United States Constitution. And yet, even though you have two separate courts, trial court and appellate court, that have said there is nothing wrong and that, in fact, this preliminary injunction is necessary to protect the plaintiffs from harm that cannot be repaired. The Supreme Court thinks in its arrogance, in terms of the majority, the majority thinks in its arrogance that it knows better. If there was ever a call for the need to reform the United States Supreme Court, I don't know what sounds more clearly than this. The Supreme Court is unchecked. It is now ruling as if it is its own kingdom or fiefdom of kings and queens. It needs to be stopped. The Supreme Court needs to be stopped. The Democrats need to figure out a way of reforming that judiciary because it is doing no one any favors. And the funny thing is, Republicans also are getting fired in these reductions in force, right? It's not just Democrats. So what are you going to do, Republicans, when you are falling victim to this reduction in force, either the Department of Education or somewhere else, and then the big bullshit bill comes and bites you in the ass even more? Because you don't get the coverage you need, you don't get the benefits you need, you don't have the health insurance you need. I mean, it's a really ugly cycle, isn't it? But welcome to the reality. Welcome to the find out part of the FA, right? Be mad, be outraged, demand accountability. Take the time to go read this opinion. It's worthwhile reading, as are all of the dissents at this point, really. But it is such a great walking through of the law and why the law matters and why it's important that Congress grows a pair and actually does its job as well. I'll see you on the other side. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.